My name is Alex, and I'm a partner with the Shipping and International Trade team at Rajah Tann Singapore. Today, we're going to spend a few minutes talking about force majeure and give you some pointers about how to draft a proper force majeure clause for your contract. Force majeure is just a convenient label used to describe a set of circumstances outside a party's control that occur after a contract has been concluded and which relieve a party from its obligation to perform the contract, either temporarily or permanently. Under some legal systems, force majeure applies automatically as a matter of law. That isn't the case under most common law systems, including Singapore law. By default, if something happens after the contract has been concluded, which makes it difficult to perform the contract, the common law provides very limited protection to contracting parties. Usually, in cases like that, unless the contract contains a force majeure clause, a party can only rely on the doctrine of frustration. But that applies in very limited circumstances and can be difficult to invoke. A force majeure clause in a contract gives additional protection and predictability by allowing parties to define when the contract doesn't have to be performed, so it can be very important to have such a clause in your contracts. Force majeure clauses can also help protect parties against claims in long or complex supply chains involving companies other than the parties to the contract, like subcontractors or suppliers. For example, you might have a situation where a main contractor engages a supplier, and that supplier is later unable to perform its part because it is affected by a force majeure event. A properly drafted clause can suspend or excuse performance of the main contractor, even if the main contractor is not directly affected by the force majeure event. This makes force majeure clauses a very useful tool to manage risk. In the shipping industry, there are many possible scenarios in which it would be helpful to one or both parties to have a force majeure clause. Port closures, export bans, the imposition of new sanctions, and natural disasters, just to name a few. Two prominent examples in recent memory are, of course, the COVID-19 pandemic, which has been ongoing since 2020, and the blockage of the Suez Canal in 2021. These are events that can be covered by a well-drafted force majeure clause, and that can save significant amounts of money by minimizing claims and disputes. So, how does a force majeure clause work, and how should it be drafted? The operation of a force majeure clause is a matter of contractual interpretation, so the clearer it is, the easier it will be to apply. A force majeure clause doesn't necessarily have to be very detailed or spell everything out precisely, but the less clear it is, the more open it will be to challenge, and the more difficult it will be to uphold if it is challenged. So, as far as possible, a force majeure clause should provide sufficient detail to make its operation clear and easy. A well-drafted force majeure clause will cover four main things: what occurrences are to be regarded as force majeure events, what effects the occurrence needs to have on the party's ability to perform a contract before the party can rely on it as force majeure, what notice requirements the parties want to have, and what the consequences of invoking the clause are. First, let's look at the occurrences that the clause provides for. These can include things like wars, natural disasters, strikes, outbreak of disease, and so on. But it's not enough to show that an event listed in the clause has taken place. In order to operate as a force majeure event, it also has to be beyond the party's control. If a party claims force majeure, but can do something to stop or overcome the event, then it can't rely on it to invoke the force majeure clause. Another point to keep in mind is that when drafting a force majeure clause, it's usually better to spell out specific events against which the parties want to protect themselves. Some clauses contain only broad descriptions that try to cover everything, like any event beyond the control of the parties. But the wider the clause tries to be, the more strictly it will be interpreted, and the more scope there is for the other party to dispute it. So a clause that tries to be overly broad might not achieve the desired effect. Secondly, the occurrence has to adversely affect a party's ability to perform a contract. But precisely what effect must the occurrence have before it is regarded as a force majeure event? This should be provided in the clause. Typically, a force majeure clause will require the occurrence to do one or more of three things: prevent, hinder, or delay performance of the contract. Each of these terms has a different meaning. To say that something prevents performance usually means that performance has become impossible, so anything less than that would not be enough. Hindering performance is usually interpreted more broadly, so it could make the clause apply to more situations when performance has become more difficult, although not impossible. Delay in performance can be applicable where the contract is neither impossible nor more difficult to perform, but just can't be performed on time. If the occurrence in question does not prevent, hinder, or delay performance, then it would not be regarded as a force majeure event. Thirdly, notice requirements. A force majeure clause should clearly spell out what kind of notice the party relying on the clause has to give to the other party. The clause might provide for a few things. How soon notice has to be given after a force majeure event has occurred. This could be immediately, or as soon as practicable, or within a specified number of hours or days after the event has occurred. What the notice has to contain. This could be the nature of the event, how long it is expected to continue, how it is affecting the party's ability to perform the contract, and so on. Whether additional notices have to be given. Some clauses require notices to be given at regular intervals after the force majeure event has occurred. It's very important to comply with these requirements because failure to give notice can disentitle the party from relying on the force majeure event. Finally, the clause should state what the effect of relying on the force majeure event is. Is performance merely suspended until the event ends? Or is there a limit on how long the suspension can last? Or does the event give one or both parties a right to terminate the contract? And if so, what precise conditions have to be met in order for that right to arise? At the end of the day, what different parties need from a force majeure clause will depend on the nature of their business and the specific contract that they are entering into. The exact formulation of a force majeure clause can vary to cater for these needs, but it's important to look out for the main points that we've discussed when drafting a force majeure clause so that you can ensure that it is effective and easy to operate. Thank you.